Good morning, good afternoon to everyone. Thank you for joining us. We start the session today with a short introduction of Faragir, which means inclusive is a global forum dedicated to empowering Afghan women. We serve as a platform for women from inside and outside of Afghanistan to build alliances, amplify their voices, and advocate for a future shaped by collective aspiration. Our mission is to address the current crisis by promoting gender
Excuse me,
equality.
Nabila Jan, I'm sorry. Please give the interpretation instructions before so everybody can tune in accordingly.
Of course. دوستای عزیز اگر شما به ترجمه نیاز دارین ترجمه فارسی میشه که در پایین اسکرین در قسمت یک علامه جهان است، یک علامه کوچک در اوجا میرین بخش ترجمه هست به لسان فارسی و انگلیسی میشه انتخاب بکنین هر کدام شک شما میخواین و به می شکل میتونین که مجلس امروز با ما یک جا باشین. So for others, yeah, of course, the session is being simultaneously translated into Farsi, Dari, and recorded. Please go to the globe icon at the bottom of your Zoom screen and select the language you will prefer to listen or speak in. Please select either English or Dari. Is it okay, Ananya Jan?
Yes, it is okay.
Okay. I continue with the mission of the Faragir. Our mission is to address the current crisis by promoting gender equality, human rights, and the rule of law. We believe that sustainable peace is only possible when the voices of those most affected are at the center of the conversation. Today's webinar is a testament to that commitment. As we move beyond the headlines to critically examine the legal frameworks currently defining the lives of Afghan women. Before we dive in, a few quick notes. As I mentioned before, so the session is being recorded and the simultaneous translation is there. I hope all the participants could access that icon. We have reserved time at the end of this program for a Q&A session. Please feel free to submit your questions in the chat box throughout this discussion. Today, we are here to critically analyze the intersection of regulation on separation of spouses and ground-level enforcement. Our title, Legislative Repression in Afghanistan, from judicial decrees to public enforcement, reflects our focus on two key pillars. The Code on Judicial Separation of Spouses, Decree number 18, and the recent wave of detentions of women in Herat related to dress code regulations. We aim to understand how these policies are systematically dismantling women's agency and what this means for the future of justice in the country. For this discussion, we have a panel. I'm very honored to have a distinguished panel of experts with us to guide us this conversation. I will introduce them shortly. Our first panelist is Muhammad Farid Hamidi. Mr. Hamidi is a distinguished lawyer and a human rights advocate who served as Afghanistan's Attorney General from 2016 to 2021, where he led critical efforts to combat corruption and gender-based violence. With master's degree in both criminal law and public administration from Harvard, he has dedicated his career to justice reform and accountability in Afghanistan. Currently, a visiting scholar in Boston College Law School, he brings profound insight into the procedural mechanics of judicial system and the rule of law. We are also joined by Wajma Farooq, a human rights lawyer and peace-building strategist with over 25 years of experience. As the founder of the Women and Peace Studies organization, she leads a network of over 200 peace builders and has played a strategic role in international justice efforts, including initiatives to codify gender persecution. An expert on the Women, Peace and Security agenda, Wajma bridges ground realities with high-level diplomacy, and she will help us connect these legal developments to the systematic policing of women on the ground. Next, we have Professor Mustafa Sheikh. Professor Sheikh is a scholar of Islamic thought and Muslim societies at the University of Leeds and co-director of the Iqbal Center for Critical Muslim Studies. His expertise spans Islamic law, legal theory, and reformist methodologies. As an author and academic who has published extensively on Islamic jurisprudence and intellectual history, he is uniquely positioned to guide our discussion on the jurisprudential interpretations currently being cited in these new legal decrees. We are excited to be joined by a guest speaker from Afghanistan. Due to the sensitive nature of her work and personal security, she will be joining us anonymously. She serves as a crucial witness to the daily reality for women in the country, and the first-hand insight on the impact of these restrictions will ground our legal and policy discussions and the lived experience of Afghan women today. Finally, I'm honored to facilitate today's discussion. My name is Nabila Musleh. Many of you might know me. I'm a human rights advocate and former Deputy Minister of Women Affairs with over 2 decades of experience in policy formulation and gender mainstreaming. I have dedicated my career to advancing fundamental rights. I am proud to serve on the Advocacy Committee of Fragir, and it's a privilege to bring these perspectives together to foster this critical discourse today. For this panel discussion, we will begin by deconstructing the legal text, then transition to the reality on the ground. Each panelist will have 10 minutes to discuss their takes. Some other areas might be covered by Q&A session. Now we begin our session and start with a question for Mr. Hamidi. We have Mr. Hamidi. Can I ask if he can turn on his video?
Yes, I was. Hi.
Oh, I couldn't see you. Yeah. Welcome, Mr. Hamidi. So happy to see you.
Thank you. Thank you. Assalamu alaikum and good morning to everyone. And I'm very happy to see very distinguished colleagues from Afghanistan and also Mr. Sheikh from the University of Iqbal. And looking forward to hear from you. And salam alaikum to everyone. Thank you, Faragir and Musleh.
Should I repeat the question or you have it so we don't go through it again?
If you ask the question again, that would be good. And also I have a suggestion. Before we are going to speak about this one, if you give time to the panelists from Afghanistan to provide an update or speak here from Afghanistan, this brave lady joining us today in this webinar. This is just a suggestion. You know how to manage your webinar.
Thank you, Mr. Hamidi. I think so. We had that discussion within our team how to go with that because we were also interested to have her at the beginning. But the structure of this session is in a way that we somehow analyze the decree first, and then we
Okay.
go for its implication, like how it impacts the life of women in Afghanistan.
Okay.
For me, it is both is fine, but while you are so important for her, so I go with your suggestion. So if she's
Thank you.
there, I would like to ask her to somehow to show that she is there.
Mm-hmm.
So our question for the guest from Afghanistan is that we understand that these laws are a reality that women in Afghanistan live every day. Could you
Mm-hmm.
share as safely as possible how these specific legal restrictions have changed the way you and other women interact with your families, your communities, and the public space? How these laws, like this regulation, along with broader restrictions on women, affected your ability to seek safety, justice, and independent life decisions, especially in light of recent incidents such as what happened in Herat. Can we have our panelists from Afghanistan?
Hi, Nabila John.
Hi, hello, welcome.
Thank you. I hope you have my voice clearly.
Yeah, we have your voice very clearly.
We
Okay,
have.
thank you very much. Good morning, good evening, good afternoon. Right now in Afghanistan, it's good evening, so I would like to say good evening to all of my sisters and brothers over here. Today I'm speaking to you from inside Afghanistan, and as you can see, you cannot see my face, but you may never know my name, and that itself is my first piece of testimony, because in my country, a woman's face has been declared a source of corruption. A woman's voice, this voice which you're hearing right now, it's been ruled as something that cannot be heard in public. And I want you, I want you to understand something, that what is happening to us, it's not a chaos. It is not a fog of war or the disorder of a broken state. It's a law. You know, it's deliberate, it's written, it's signed, and it's stamped. So decree after decree, we have verdict after verdict, and each one drafted in an office. It's been approved by a ministry, and then it's been carried into our streets, our schools, and our homes. So let me tell you what that looks like, but not in the language of reports, but in a language of someone living inside Afghanistan, in a language of a life. So the way we see it, the way everything is, it's the life of a young woman who have spent 6 years. Imagine someone who has spent 6 years studying medicine, 6 years of sacrifice, 6 years of hard work, 6 years of so many dedication. And that person's been told that before her final exams that the universities are closed, her dreams all shut off, all canceled. What? In writing. They've told you cannot study, you cannot pursue medicine anymore, and that's it. To me, it looks like as someone who's unable to walk to the market without a male guardian, unable to enter a park, a gym, a bathhouse, and unable to work in the most professions which are available here. Unable under the morality law which is passed on August of 2024. I cannot raise my voice in public, whether it's to sing, whether to recite. I cannot even laugh too loudly here. So what the law does, the law calls my name Aura, which means it's something intimate, something shameful, something that needs to be covered. And here is what I need the world to grasp. These decrees, they do not stay on paper. They walk, they patrol. The Ministry of the Vice and Virtue, or the Prevention of Vice, they have their inspectors in our streets. They stop the cars to check if a car is having a woman. Is she traveling with a guardian? They ask questions from the taxi drivers. They detain girls over the way if the scarf is not properly worn on their head, whether the color of their scarf is black or not. enforcement has been handed not only to officials, but to everyone, to the neighbors, to the shopkeepers, to the strangers. Because, you know, the state is trying to criminalize a woman's existence this way. It deputizes the whole society against her. Even at that moment, a girl comes and asks for help. Nobody would dare to help her or support her in any way because of that law. Just weeks ago in Herat, the morality police swept through the streets. They were detaining these women, you know, over the way of hijab that they were wearing. The different color that they were fully covered. Let me tell you that. They were all fully covered. The only issue was it was in different colors in different ways. And a woman speaking there, she anonymously said that the city has fallen silent. Young women are too afraid to leave their homes, all because of the imprisoning that's been going on, because women or girls are being covered, but in a different way. Let those words sit with you, please. An entire city, 1 million people, they're all silent. They're not silent by bombs, but by a dress code on women. So this is the journey I was asked to describe, from judicial decrees to public enforcement. It's a short journey. So a fatwa becomes a fist, and a paragraph becomes a prison, and the prison is the size of a house, and the prisoner is every woman in it. They're calling this justice, but I ask you, what court did we stand before? What crimes were we charged with? What defense were we allowed? We were tried in absence. We were convicted of being a woman and sentenced to disappearance. But yet, I mean, we're still here. Girls, they're studying in secret rooms, over hidden phones. We have these whispered lessons going on. And women, these amazing, strong, hardworking women, they're running underground schools knowing that the cost of discovery can have really huge consequences. Mothers are still teaching their daughters that all of this, it's not normal and it's not going to last forever. So every woman who learns in secret in committing an act of resistance, every voice that escapes this country, like mine tonight, is a crack in their wall of silence. So I'm not here to ask you for your pity, because pity changes nothing. I'm here to ask for your refusal. Refuse to let this become ordinary. Refuse to let gender apartheid remain just a phrase in conference halls. Demand that it should be recognized, named, and prosecuted as the crime it is. Now, please refuse to normalize any government that tries to erase half of its people by a decree. They have taken our schools, our work, our government, our faces, our voices, and there's just one thing that they have not been able to take away from us is our will. It will survive every edict, and it will outlast every decree. I began by telling you that you cannot see my face. You may never know my name, but hear me now, and please carry this with you when the webinar ends. We, Afghan women and girls, we're not gone, we're waiting. We are asking the world, the international community, to please do not look away. Thank you.
Thank you so much. So I get so emotional every time when I listen to the women of Afghanistan from inside, what they have to say. And that is the reality. It was so powerful. Thank you so much for explaining the situation in this way. Now we can continue with Mr. Hamidi with the question about the law. Given you a background as the former Attorney General, how does the Code on Judicial Separation of Spouses, Decree number 18, fundamentally undermine established legal protections for women? In what ways does this decree replace the rule of law with a system of arbitrary state-sanctioned control?
Thank you. And first of all, I thank you, the brave lady from Afghanistan, and the way that she explained the very dire and painful situation in Afghanistan. It's very dire situation. After all of this explanation from Afghanistan, I think many of our questions or many our concern, now it is clear what's happening in the country. Speaking about the decree number 18, issued in May 2026, it's not just the problem of Afghanistan. We should look at to the broader context and broader picture of the regime that ruling Afghanistan, a regime of apartheid. As you know, from August 2021, when the Taliban took over the country, more than 100 decrees just published and executed to control and to suppress the rights of women in Afghanistan. Control mentally, physically, socially, culturally, and imposing a total and brutal apartheid regime. All the system of governance, the rule of law, the justice system, the laws and regulations, the organizational culture of this regime, the administration is to control and to limit and to eliminate women from the society and ban them from enjoying at least the basic rights a human should have to live in a society, to live in a country. All those achievements that Afghanistan made in from 2002 to 2021, abolished and destroyed by the Taliban, and instead of that, they designed a system of governance, and as I mentioned, the laws and regulations, how to control the people of Afghanistan and how to limit their rights and freedoms, especially how to eliminate and erase women from the society and control mentally, physically, socially, culturally, and economically. As I mentioned before, the Civil Code of Afghanistan, which was issued in 1977, because you know Afghanistan is an Islamic country, and the laws and regulations historically coming from the Islamic Sharia. The criminal code of Afghanistan in 1977, which was lasted to 2017, and after that I could remember participation of the Deputy Minister of Women Affairs in Afghanistan in all those meetings, the drafting committee, and also Washma John Farooq from civil society and other colleagues here. They work tirelessly to include the women rights in every regulation of the country, because the policy of the government on that time was protection and promotion of human rights, and especially women rights, because of the historical oppressions that women in Afghanistan experienced. All the regulations, all the systems of the country, all the governance systems of the country, the policies of the country was focused how to find the new ways and establish new laws and mechanisms to provide promotion and protection for women and children in Afghanistan. The civil society was very active in this regard, and we can name hundreds of laws and regulations that was based on this policy. But as I mentioned, in 1977 Civil Code of Afghanistan, it is very similar to this degree of 18 of the Taliban. Because in the Civil Code of Afghanistan, there was an article that was permitted the father and the father of father to for how to say in English, to give to the nikah lady, it's under 16 years of age. Because the lawful age of a girl was 16. But also there was an article to permit the father and the father of father to give a girl under 16 to be married without the consent and without asking that girl. But on that time, there was another responsibility from the governments and administrations, especially during the Republic of Afghanistan. Thousands of civil society organizations was providing promotion and protection for women. There was access to justice. There was access to defense lawyers freely, and many organizations, even the government of Afghanistan was obligated to provide access to justice and also access to defense lawyers to those ladies if they have any problem. There was commitment of the government of Afghanistan before the international community and international instruments and international human rights laws. And there was a lot of organizations inside the government of Afghanistan to provide protection for those women. They wanted to stand before the courts and stand by law and ask for their rights. The specialized units of police was leading by female police. Specialized units of Attorney General Office was leading by professional female prosecutors. The courts, family courts, and also courts against violation against women. All over the country, there was very safe houses for those women. They were seeking justice and also seeking promotion and protection from the government and also from the society. All of those mechanisms, organizations, policies, national plans, regulations, and laws abolished by the Taliban, and they created a system of apartheid, as I mentioned before, designed just for controlling and suppressing the rights of women. For implementation of these laws and regulations, there is not just laws and regulations and also the mechanisms. The person who is judging, a judge, the mentality of a judge, the education of a judge, the education, the background of a judge and a mufti in the court is very important. This one. All of the Taliban, all of the judges of the Taliban belong to the ideology or belong to the political party of Tariq-e-Taliban. There is no any separation of power or separation of branch to balance between the government authority and also to protect and promote the rights of the citizens. All the judges and courts of the Taliban have a mentality against women. They believe in erasing people, women from the society. they believe how to find new ways and how to find new fatwas to control and to limit the rights of women, because there is no constitution written to people of Afghanistan know about their rights and freedoms and also their obligations and their privilege. All the time, the muftis from the courts, they are looking to thousands of fatwas during this 1,400. There is many ulamas. We cannot find a fatwa that is like every ulama's consent on this one. There is a lot of fatwas, and every court of the Taliban, they have their own decision and their own fatwas, because there is not any regulations. If there is regulations like degree number 18, it is very vague and provide opportunity for the judge and for the courts and for the muftis to find ways for providing more access and more privilege to the man than the woman, and to limit the rights of the woman. Just a new news, a breaking news yesterday. There was a father, addicted father in Jalabad, and he gave his 13 years daughter to a person which is like 70 years old. And now the mother of this girl and also the grandfather of this girl going to the courts and asking the courts to separate this one and to annul the nikah. But the courts decided in favor of this old man and approved the nikah between this lady and also the man which has 70 years old. I think in this situation, it is a very dire situation, and the degree beside another degrees and regulations, the mentality of the Taliban officials, especially the mentality and ideology of the judges of the Taliban, the muftis of the Taliban, all hand to hand together, providing a system of apartheid, which we can see every day in Afghanistan. And it is a dire situation, and I'm asking in this webinar the international community and also all Afghans inside and outside of the Afghanistan to stand against this brutal and apartheid regime of the Taliban, and to eliminate all the efforts and put pressure on the governments and the state to not normalize engagement with the Taliban, because human rights and especially women's rights is not an issue of separating from the world affairs. It is not possible. It's not for the sake of the humanity, and also it's not in the sake of justice and security of the world. The women of Afghanistan, the people of Afghanistan is suffering, and the human rights is abusing every day. But we can speak about humanity, human rights, and women's rights in a global stage. Thank you for providing me this opportunity to speak about this very timely and important question. Thank you.
Thank you so much, Mr. Hamidi, for your analysis, for your input, and for your life example of that girl, of 13 years old girl. And it shows that this law has no protection for women, no mechanism at all for women and girls to be protected. So that is very clear. It relies on the family, it relies on the judge, and all other mechanism and person, not the person and the girl or woman herself. So that is the problem. Thank you so much. I think we will get more questions on these, perhaps on the chat box. I'm requesting participants to share the question and thoughts in the chat box to later in the part of question and answer to go through it and also give another chance to panelists to talk about them. بازم خواهش میکنم از دوستا اگر سوال دارن میشه که سوالای خود در چت باکس همراه ما شریک بسازن. تشکر امیدی صاحب از شما. بازم با شما خاط بودیم، صحبتای شما را میشنویم. بعدا هم فعلا now we would like to continue with Ms. Froh. The question to you is, to what extent does this regulation conflict with international human rights standards on gender equality and access to justice? And how might it relate to broader incidents such as the recent case in Iraq in terms of systematic protection failures for women? The floor is yours.
Thank you so much. Assalamu alaikum to everyone, and so delighted and honored to be here in presence of very esteemed colleague Hamidi Saib and so many other distinguished colleagues. And I also want to express my gratitude to our sister from Afghanistan, who spoke so eloquently, so beautifully about all the pains that they are going through. I would start with a central argument here that Decree number 18 is not a family. It's not a family law regulation. It cannot be actually examined in isolation, but this is a part of an expanding legal and administrative framework that increasingly limits women's ability to exercise agency over their lives, their bodies, seek protection from harm, and access equal access to justice on basis with men. So why am I arguing that? Is because all different provisions of this law is actually in complete contradictions with the international human rights standards, but also some of the international norms that we have actually accepted as part of fair trial and fair justice systems. So the first thing I think which is so critical is the equality before the law. One of the most fundamental principles of international human rights law, even the international norms, is equality before the law. And this is something that we all worked so hard in 2004 when we got the Article 22 in the Afghan Constitution, which gave women and men equality before the law. And that's one of the first provisions or principles of international human rights law, is that women and men are provided, or other people, and even other countries are also even increasingly identify or recognize other genders as well. But women and men should have equal access, equal standing in the law, or equal before the law. And this is a principle that's founded very much in the Universal Declaration of Human Rights, even when you look at the International Covenant on Civil and Political Rights, CEDAW, the Convention on the Elimination of All Discrimination Against Women, all these different, international, and even when you look at UN security resolutions, including 1325, all of them recognize women equal before the law. So any regulation or any law that does not ensure that women are equal before the law is actually in a full contradiction with the international human rights norms or standards. And the states, actually, these standards or the international laws require the states that they should have, they need to ensure that women have equal legal capacity, but also equal access to remedies, to reparation, to compensation when they are being harmed, and equal protection mechanisms. The rights are protected. But the concern or the issue with Decree number 18 is that it actually creates unequal barriers for women who are seeking legal remedies, who are seeking divorce or separation. For example, when you look at like violence, domestic violence, or abusive marriages, which is like a major challenge in Afghanistan right now. I remember the latest report that we have from 2021 that it showed more than 90% of women in Afghanistan experience domestic violence. So imagine right now that violence has literally doubled and tripled in the absence of all institutions that protected women once before the Taliban. So imagine if one party, like if women, facing so many burdens in accessing legal remedies because she like wants to sort of get separated from that marriage, the law does not actually favor her. That the law is not even accessible to her. So that's where, you know, her human rights starts, the treatment actually, you know, is in conflict with her dignity. There's no equal protection and there's no equal access to justice. Another principle in this law, which is like very, very problematic, is about child rights, for example. This decree, I should not call it the law. I need to ensure that we call it a decree. This decree actually linkages marriage to puberty and interprets, you know, the minor's silence as a consent. And this is from, you know, when you look at the CRC, the Child Rights Conventions and International Human Rights Standards, that's a complete, you know, in conflict with that because children cannot provide consent. Hamidi said provided an example of a 13-year-old girl. And we hear that on daily basis from Afghanistan, where families are marrying their 12-year-old, their 13-year-old, also to get protection from the Taliban, but also, you know, because the imam or the mullah that's actually reciting the nikah, they think that, or they assume that the consent is acceptance, but consent needs freedom. It needs capacity. A child does not have the capacity to provide consent, or understanding that, you know, it actually, what would happen to insert in like a child, 12-year-old does not even understand what happens if I'm married to this 17-year-old man. So the pressure, the fear, dependence on the family, lack of awareness about the consequences, all of that is not consent. But, you know, and this is what the International Child Protection Standards, the CRC, and so many other, you know, optional even protocols, they were developed primarily to prevent child marriage, to prevent children from, you know, getting into these pressures. The principle of effective remedy. So internationally, rights have no meaning if there are no remedies, if there are no compensations, if there are no protection mechanisms. So a woman should be able to not only challenge abuse, she should be able to seek separation if she's in an abusive marriage. She should be able to seek protection, and she should be able to seek courts. But women in Afghanistan, like in the current situation, they have access to none of this, because there's no access to justice, but also the moment she gets into the court, or with all the challenges, you can see what happens to her, because the law turns a very blind eye to the pain of women, but not only it turns a blind eye to the pains that women are going through, it actually favors the abuser over the woman. And you know, the access to courts. So for example, this decree from a legal standing point is a very meaningless decree in terms of the legality of it. But for people who are implementing it, this has become a very much, you know, a big green flag. This gives them the right to police women's lives. And what we saw, for example, in Herat, that this is not like what happened in Herat, the systematic protection failures, or the systems that are in place, the administrative frameworks that are in place, is actually created in a way that they are, you know, oppressing women in a very deliberate manner. For example, women were stopped in Herat. They have been stopped. They have been questioned. They have been detained. They have been punished. They have been humiliated. So that actually shows that, you know, there is a huge imbalance of power between the state and the women who are willing or like trying to seek protection, for example. Like imagine if how any woman in Afghanistan right now, like 12 million, we estimate that there are 12 to 14 million of women right now living in Afghanistan. And all of them do not have access to any of the systems that were in place that Hamidi said talked about. For example, protection in the law. The law was actually the understanding of the pain and the violence that women were going through, and also in all those different institutions that try to support women. So that's why it's a very, and of course, in terms of, connecting it with the international human rights mechanisms, it's a complete, contradiction. So the question before us is simply that not this decree complies with any legal standard. The question is whether women are, continuously becoming unequal rights holders, like they are not considered to be right holders in Afghanistan. Their reality, their existence do not actually matter in as an individual, but in relation to men, to other family members, even, the examples that our sister provided and also our colleagues on the ground share with us. So all of this deliberate system that we have been talking about, this administrative, framework, all of that actually, constitute gender apartheid, but also gender persecution. So that's why the International Criminal Court, for example, last year, issued the arrest warrants for the leaders of the Taliban because they have been found guilty. They have been charged with the crime of gender persecution, which actually is an international crime. But all of what's happening in Afghanistan, also like in terms of the systematic, failures to protect women, but also deliberate efforts of these administrative frameworks that oppresses women, these are also constitute gender apartheid. So while the gender apartheid has not formally codified, but it is being, discussed as part of the international laws, because what's happening on the ground, like the discrimination that women are actually going through, it's not, it's not just coincidental, but this is part of the Taliban administration. I'll come back to other questions. I'll stop here. Thank you.
Thank you so much, Wajma, for your great analysis of the decree. As you mentioned, we shouldn't call it law. We should call it decree, a fun one. Thank you so much. I would like to ask participants if they want to share their questions, their thoughts in the chat box. The question will be reviewed and answered. I think that would be the easier way to cover all the questions somehow, because we wouldn't have that much time to give space for everyone to talk. I see the Anna Boone hand raised, but definitely we will give a time when we have the Q&A session. Thank you so much, Wajma. Now we go to the next question. To Professor Sheikh. Professor Sheikh, we would like to know, we often see these decrees framed within a specific interpretation of Islamic law. As a scholar of Islamic thought, how are these authorities utilizing legal theory to justify the removal of women's agency? How can we critically engage with these interpretations from a reformist perspective?
Thank you so much for that very important question. Assalamu alaikum to all of you, and to the audience, and to the esteemed panelists who have spoken powerfully, and I've learned so much already from the contributions that have been made. The Taliban present the removal of women's agency as somehow the fulfillment of Islamic law. That should really worry all of us. The Penal Code, Decree number 12, the Book of Criminal Procedural Regulation of the Courts from 2026, and also the 2024 law on the propagation of virtue and the prevention of vice, are both written in the vocabulary of classical fiqh. So we see terms like ta'zir, maslaha, hizbah. We see the authority of the imam or the supreme leader, who is there defined as the one who regulates conduct. So we see that vocabulary. What strips women of their agency is not the vocabulary, but the way in which the implementation of that law is taking place. And in my analysis of the different codes, I've discerned, I have seen 4 jurisprudential moves that produce the various codes' most indefensible provisions. These are moves that borrow classical Islamic terms while discarding the constraints that classical jurisprudence attached to them. So let me explain. 4 mechanisms. The first mechanism is turning the permissible into the forbidden by decree, not by revelation. So we have to note, and we have to be clear, these are decrees. These are not by revelation of the Quran and the Sunnah and so on. The code allows acts that are ordinarily mubah, permissible, to become obligatory or prohibited the moment that the supreme leader commands it. A genuine usul violation, since the 5-fold classification of acts, which many of us will know in the Sharia, wajib, mandub, mubah, makruh, haram, they rest on revelation and juristic reasoning, not on executive fiat, as and when the supreme leader chooses to issue a decree on the basis of a dream or on the basis of his predilection or on the basis of some other thing. And we see this as the position of all great classical Muslim jurists, like, for example, Al-Mawardi's doctrine of obedience to rulers. For these great jurists, our obedience to the rulers only concerns administrative order. It doesn't allow them to reclassify moral categories and then bind us to follow those. This is exactly the mechanism behind the dress and speech provisions. The law on the propagation of virtue and prevention of vice, Article 13, legislates full covering of the face, the Sharia hijab or niqab. But the transmitted Hanafi position, as recorded by Ibn Abidin and Al-Kasani, this is the very school that the Taliban profess to be following, holds that a woman's face and hands are not awrah, and that covering them is a precautionary recommendation, but certainly not an obligation. So what was mubah, and maybe at most mandub, becomes wajib by administrative command. The same clause runs in the other direction of speech, the speech of women. Article 13.3 requires a woman's voice in song or recitation to be concealed. Article 22.10 classifies the sound of a woman's voice from any gathering or home as a punishable wrong. Nothing in the transmitted tradition renders a woman's speech haram. The most cited female authority in the entire Sunni hadith corpus is Aisha bint Abi Bakr, the wife of the Prophet. She's remembered specifically for transmitting revelation and hadith through her own voice. Criminalizing it by decree reclassifies by fiat the very faculty the tradition depends on for its own preservation. Education and employment bans belong to the same category. Acts long debated and conditioned within the madhahib, never foreclosed, converted into prohibitions by executive order rather than by any kind of argument from usul al-fiqh. The second move that I have seen is maslaha detached from juristic discipline. So classical maslaha or benefit is not free-floating. It operates inside textual coherence and a structured harm prevention discipline. Strip that discipline out and maslaha stops being a jurisprudential tool and becomes sovereign will. So take, for example, the mahram travel requirement. It shows what I'm saying precisely. Its classical scope, as for example Al-Kasani sets it out, was bounded to journeys of 3 days or more. This is a protective measure in pre-modern times against the specific dangers of long travel, resting on the unqualified affirmation across every school that a woman of sound mind and mature age holds full legal and contractual capacity, or ahliyah. Extended to every journey and enforced even where the designated mahram is himself the source of harm, this same requirement stops preventing harm and it starts to produce it. And this is exactly what the Taliban have implemented in their version of the travel ban. Because the way that they have implemented closes off the route even to a doctor or to a court or to safety for a woman. So this is maslaha pushed past the point where its own logic still applies. And the third thing that I've discerned is where hisbah is collapsed into ta'zir. So the code grants private individuals coercive punishment authority that the classical tradition reserved to the judges. In Hanafi classical material, you will find time and again, al-qada mufawwadun ila al-qadi, that it's the judge who has the authority to impose ta'zir. This is explicit in the Hanafi tradition. Unauthorized enforcement was condemned because it generates fitna in the language of the classical jurists. In the provisions on women, this collapse reaches its most intimate scale. A husband is granted authority to administer discretionary punishment directly, and any Muslim who witnesses sinning is granted that same authority. Punishment doesn't move merely from the courtroom to the street, it moves into the home with the person, a woman who, the person who a woman should be safest with, made as her judge and enforcer. The consequence is visible in how the same code values the resulting harm. Violence against a wife is punishable only where it produces some physical fracture or bruising. So the burden of proof rests on her to show that she has experienced physical harm, that her body has come to harm. She must reach a judge to prove that, to show her body, to show the bruising that has happened, accompanied by the mahram, who may be her abuser in the first place. And the maximum penalty, which I find shocking, is 15 days imprisonment for any husband who has enacted violence on his wife, if proven in court. Cruelty to animals carries 5 months. Trespass on someone's land carries 2 months. So let's just compare in the way in which women are being treated. They're right down not just the bottom of the human hierarchy, but on the hierarchy of animate beings. The same privatization closes the one route out. A woman who leaves a marital home without permission or against a court order faces imprisonment, as does anyone who shelters her. No school of classical jurisprudence supports this. Every school holds that a woman facing harm has the right and the obligation to remove herself from danger. The same underlying move, keeping the decision inside the husband's authority, even where the process is nominally judicial, reappears in the decree's provisions on how a wife may exit the marriage altogether. Decree number 18 that we've been discussing allows a wife to petition the court against a husband who oppresses her, who fails to fulfill her rights, muta'annit, or where serious discord exists between them. And there's a requirement that, as in the classical tradition, there are 2 hakams that are brought. These are arbitrators, one from each family, tasked with reconciliation. Where the arbitrators find the husband is muta'annit, oppressive or obstinate, the court may compel him either to end the oppression or to divorce her. This looks like relief on the face of it, but actually relief is emptied when we realize that the court can decide that if the oppression is addressable by other means, short of separation, then in fact that marriage should continue and facilitation should be made for that. And the woman is not then actually able to achieve the separation that she may very well need and require. So these are some of the important things. Number 4, manufactured uniformity, where the tradition holds either plurality or a settled baseline. This is something else I've discerned in these provisions. Classical jurisprudence holds every human being, regardless of sex, to be an independent rights holder, dhu haqq, before God and before the law. This is a principle the Quran itself grounds in its declaration that God has honored the children of Adam without distinction to sex. The code of the Taliban abandons even this settled baseline. Women in the code come up again and again as the category of wife, not as independent legal persons, where the social stratification and doctrinal execution provisions examined that I've already examined erase a plurality the tradition actually held, this erases a point on which the tradition was largely uniform. And I want to make a final point about the ban on education, because this is fundamental to the legal questions that we're talking about. The ban on girls' education beyond primary level removes the precondition for contesting everything else described so far. So every argument advanced in my response that, for example, dhu haq status is unconditional. The transmitted Hanafi position on the niqab is that it's only recommended, it's not an obligation. The mahram rule that I've talked about, the ta'zir cannot be delegated to a husband. All of this knowledge depends on access to the legal tradition that contains that knowledge. A woman denied education beyond the primary level cannot read the legal corpus. She cannot verify a judge's or an arbitrator's account of what her own school actually requires. She cannot argue her case before a judiciary that is now entirely male. The right to appeal to law presupposes the capacity, the ahliyah, to know what the law is, and women are being denied that. And so there's an information asymmetry there. It's a structural asymmetry, and I think that's something that's really important for us to recognize. I realize, Nabila Jan, that I've already spoken for 12 minutes, and I didn't yet get to the question of reform, and perhaps that's something I could address in the question and answer, if you prefer.
Thank you so much. Thank you so much, Professor Sheikh, for your thoughtful and fruitful on decree number 18. I think it was very useful for all of us. We appreciate your takes, especially with all the points you mentioned, directly focusing on articles, bringing examples of pre-modernity and current life situation, and most importantly, by mentioning and bringing the beautiful example of Prophet Muhammad. Thank you so much. I'm sure that there will be lots of questions for you. Thank you so much for your input for now. So now is the time for our Q&A session. So far, we haven't received that much question here, but I would like to ask my colleague Ananya John if there are any questions that we want to share now. Otherwise, I can give the floor to Anna if she still wants to ask the question that because I saw her hand raised a few minutes ago. I'm seeing lots of greetings.
There are more comments on the chat than questions.
Okay. So I would like to ask participants if they want to share their views. Please raise your hands that we give you time to speak up. Anna, if you are there, please, it's your time to speak.
There are two questions also in the chat. There
Yeah.
is Rinda Narayan who's asked, could you perhaps also tell us more on what can be done by women in these situations where there is no legal recourse? And Kohi Ali asks, what specific roadmap and strategy do you propose for our people in Afghanistan to execute? Furthermore, what is the distinct role and mobilization plan for our youth, both young men and women, to drive this change?
Thank you, Ananya. So our panelists, they have the questions. So if we want to have someone from the participant to speak, I don't see any hands raised so far. We can go back to panelists to answer the questions that we are having on chat box. Yeah. So these two questions we have for now, I would like to ask Amidi Saib, Wajma John
There is
and
a
Sheikh Saib.
comment in chat that Vrinda says that her question was mostly directed towards Vashmajan. So
Okay. Wajma John, please go ahead with that part. Thank you.
Thank you. Thank you, Vrinda. It's actually, the question is like all of us have that question. But I want to share that, and also kind of echoing what our sister mentioned, that with all what we hear, with all what's going on with the women of Afghanistan, they have not given up. They continue to do so many things inside homes. And that's what I also witnessed with working with so many of them. So I think in terms of support mechanisms, because there are no official support mechanisms outside home, but inside homes, what we have seen is that the violence that women are going through have tripled and quadrupled because of the poverty that people are also experiencing. So women have been telling us that if you help me earn, an income, if you help me learn a skill, if you help me, engage in an activity that actually it can help my family, it decreases the level of violence. While there's no correlation between violence and, abusive marriages, but there is a correlation between improved economic or livelihood situation and the level of violence that women are going. So my personal experience, I've seen and worked with so many women that while we have tried to, help her gain a skill and then maybe start a home-based, activity that earns her, an income, that has actually helped her kind of deal with the situation, because it puts her in a better economic situation. It puts her in a situation where she can actually, kind of negotiate rights. And this is something that in the current, context in Afghanistan, one of the few, grounds that still is there to support the women. That's why I continuously ask for, support to women's groups, support to women organization, continuously investing in these local groups that actually have support. Because even for example, we work with women who are not even able to buy the 500 AVS top-up card for their phones, so that they can be connected with and talk to each other, for example. So even the mere fact that if you're able to support women with communications, with, for example, a skill, with a micro grant that she can start, a home-based activity or a home-based livelihood, effort, even those actually, impact the situation. I also want to add that in terms of the community mobilization, so we know that there are efforts. I cannot give more details, but I know that there are efforts within the communities between women groups that actually reach out to elders in the community who are intervening in cases of child marriages, for example. And this is part of those self-help groups that many of the local organizations and local women groups have established. Thank you.
Thank you, Ajmajan. Thank you so much for this great answer. Amidi Saib, would you like to add a little bit on that? Or there is another question that I'm also seeing for Mr. Sheikh. Amidi Saib, you can go ahead. The floor is yours.
Thank you. I think in this situation, education is very vital and important for girls in Afghanistan, which one way is the online schools and universities provided by Afghans and international organizations and Afghan civil society and Afghan diaspora. How to encourage people inside Afghanistan to turn their houses to a school for their girls. Every father and mother, they have the opportunity, or relatives, close relatives, they can provide this access to education in the families. They have this huge responsibility, a human responsibility for the future of their kids and for especially for their girls. For diaspora and people, they are sending help and especially money to their relatives from outside Afghanistan, because now the economy of the entire country is depend on the donations and financial support that Afghans are working abroad and sending money. I think a portion of this help or this support should be allocated for providing expenses for girls of the family. They can do this for providing access to the online internet and phone, because the only way that the future of Afghanistan is going is through education. And as you know, in Afghanistan now, the girls doesn't have this opportunity to access to the education. Even the quality of education in Afghanistan for the boys also, it's very intentionally lowered by the Taliban to support participation of people in Taliban-controlled madrasas. The other issue, I'm asking the families in Afghanistan, based on the reports, very credible reports, of sexual harassment of boys in the Taliban-controlled madrasas all over the country, the girls' harassment in their madrasas, and also the education of Taliban-type education of Islamic education in madrasas. It's very dangerous for the future of Afghanistan. There is a lot of madrasas independent from the Taliban curriculum, independent from the Taliban ideology and policy. If they are interested in religious education, I'm sure every family, every mother and father in Afghanistan have the ability to teach their girls and sons about the very important teachings of Islam, because every one of us, even we have degrees from the universities inside and outside of Afghanistan, we have a good level of understanding of Islam thoughts, Islamic values, and important issues for our Islamic beliefs. The people should stop sending their girls and sons to Taliban-controlled madrasas. By promoting education for girls and boys, we can provide a situation of making the future of Afghanistan brighter. Thank you.
Thank you, Amidi Saib. So we have also a few more questions here. I think those questions are for Mr. Sheikh. Where are those? Here. Professor Sheikh, for a compelling presentation, would it be possible for you to set out in writing your legal arguments regarding the Taliban's decree on the separation of spouses and share them with international organizations that engage with the Taliban on policy matters? I believe this could provide a strong legal foundation for the advocacy and engagement. There are fundamentally legal issues, yet many people working in this area may not be familiar with that detailed legal arguments involved. So that's question for Mr. Sheikh. Would you like to answer that? And there was another question from Timur that I cannot find here.
Yeah, I think Timur was asking what could be the reason for the Taliban enforcing classical Hanafi fiqh, and why.
Exactly. You have already did it. Thank you.
Maybe
the floor is yours. Please go ahead.
Thank you. I'd like to start with Timur's question. And I think the Taliban's authority rests entirely on their claim to represent true Sharia. They can dismiss a human rights framing as a Western imposition. They cannot as easily dismiss a challenge built from Hanafi procedural doctrine. And I think, therefore, the fact that they're implementing Hanafi fiqh is both a strength for them, and that's how they legitimize themselves, but it's also their Achilles heel, it's their greatest weakness. And this is what I've tried to show in my analysis. Now, I think that there are things that need to be done in response to the question on what can we do? How do we move forward? How do women acquire rights in a system which is fundamentally structured to prevent them from achieving them? Education, I've mentioned in my presentation, is fundamental. One of the things that we need to understand through education is that fiqh is separate from Sharia. So what's being enforced on women in Afghanistan is fiqh, which is a human, historically situated juristic interpretation of men, fundamentally, which is dressed as Sharia itself. So here, reformist engagement should press the distinction very consistently. A narrow reading among many, among many, the tradition has historically accommodated is being presented as revelation, as Sharia. We also need, and this is by a deep and close reading of the Hanafi school, we need to recover plurality in a context in which the Taliban have really narrowed the Hanafi school. So we must name the transmitted sources within the Hanafi school that the Taliban are claiming to be implementing, that they already record positions on dress and legal capacity that are contradicting what the Taliban are enforcing. Making these specific checkable citations visible is a stronger tool than a general appeal to pluralism and so on. So I think that's something that's a very powerful thing that could be done. We must treat legal and religious literacy as part of the remedy for what we're trying to do, not just a precondition. If you accept what I argued, that there's an information asymmetry that allows the mechanisms to function, closing it is not a humanitarian goal, but closing the asymmetry is fundamental to actually achieving the kind of emancipation that we want. So we need scholarship, we need translation of primary texts, we need legal literacy programs for Afghan women and girls delivered wherever possible. And I think it's going to be primarily through diaspora networks. Unfortunately, a lot of the leading juristic minds are now in exile. But we need to do this to restore the specific capacity that women have to be able to assert their rights. And just one final point around reform. We've had I think one of our panelist members has mentioned, I think it was Nabila Jan yourself, about the laws on separation and the marriage or the betrothing of a minor, and that she's entitled to, of course, separation if she wishes at the point at which she reaches bulugh, khiyar al-bulugh. I think it's really important to recognize, and very few people are aware of this, that in pre-modern times, bulugh or maturity was ascertained through, for a girl, menstruation, and for a boy, a wet dream. Those were proxies for maturity. They weren't definitive signs. They were their proxies in the absence of it determining intellectual maturity, which is the requirement of the law becoming an obligation on a Muslim to follow. We now live in a time in which we don't need those proxies as determinants of intellectual maturity. We understand the way in which brain development functions. We understand the ways in which psychological maturity works. And actually, the argument has to be around there, that the Sharia can accommodate the idea that intellectual maturity, which is a prerequisite for the following of Sharia, is something that's much later than 13 or 11 or 10. This kind of religious literacy is really important, and unfortunately, I think we've had years of calls from among the reformist legal minds that we need to do this work. Otherwise, we're going to have a situation like we have with the Taliban. And lo and behold, this is the situation that we find ourselves in. And so now we have to work very hard to get to that point, that point in which we can have these conversations.
Thank you, Professor Sheikh. Thank you so much for your answers, for your inputs. Very useful. Do we have, Ananya, do we have any question for our guest from Afghanistan?
No, there are no specific questions from girls in Afghanistan on chat or something that has not been addressed yet. Maybe give a last chance to everybody to ask a question. If there were some comments, maybe in Farsi, I'm unable to read, but no question.
Okay. So I already asked all participants to raise a hand if they have any questions. So far, I don't see at least any hands raised, but I would like to give another chance to the lady from Afghanistan if she has anything to add to the discussion that we had today. If she has any question to other panelists. I think we don't have her with us.
Might be due to limited internet connection.
Yeah, that can be. Exactly. So we have actually
Yes, can you hear me now?
Yes, I hear you very well. Please go ahead. The floor is yours.
Can you please your question again? I'm sorry, I missed it.
I would like to know what you think about the discussion that we had. Is there anything that you want to add? Any questions? Any requests from us outside Afghanistan?
Thank you, Nabila Jan. What I would like to request is that please, the international community, people who are outside Afghanistan, not to forget about this. As a person, as a woman, as a girl, speaking from inside Afghanistan, I want everyone to pay very attention to this matter. I know what's going on in the other parts of the world is as important as is what's going on in Afghanistan. But right now in Afghanistan, what we're going through is that it's more than a merry change or a merry law or just a merry restriction going on. If you think a country whose more than half population completely might be women and girls, they're deprived from education, they're deprived from work, they're deprived from medical assistance, they're deprived from so many things. How can a woman or girl live in such a country without going so much through? Because if you're in any country and you're not given the right you have, you would not be able to live in that country for a second, for a moment. You would feel you don't belong to that country. You would feel that you are not welcomed in that country. And as an Afghan woman, I'm talking about my own country. I was born here, I was raised here, I studied here. And then now I'm being deprived of every right that was given to me as a human being by my own people, by my own government. So please refuse anything that they're saying, and please try to support us in any way, because this is the time when our country needs more funding, flexible funding, more support, more resources, so we can support whatever these women and girls are doing in underground bases. Thank you very much.
Thank you so much for your input. So I think it is the time to conclude our session today. As we conclude today's session, as Professor Sheikh mentioned, it is clear that we are not just discussing a legal document, but the systematic dismantling of women's autonomy. So that's very clear. The quote on judicial separation of spouses decree number 18 and the recent enforcement actions in Iraq are two sides of the same coin. The Taliban's move to institutionalize gender-based control, whether through the courtroom or on the streets. The aim is the same, the erasure of women's agency in public and private life. Our panel today has highlighted that silence in the face of these developments is not an option. To move from awareness to impact, we call upon all participants and broader international community to first continue to meticulously document the impact of these decrees on the ground. Your data is the primary evidence used by international bodies such as the UN and human rights rapporteurs to demand accountability. Second, to use today's insight to inform policy briefings, advocacy campaigns. We urge you to amplify the voices of Afghan women and civil society, ensuring their perspectives remain at the center of international diplomatic engagement. Third, the most effective defense of rights often happens through local informal networks, which is why we encourage you to support initiatives that provide legal awareness and safe communication channels for women inside Afghanistan. And finally, to not allow these new decrees to be normalized. Each directive is an incremental step toward total exclusion. It's our collective responsibility to keep these issues on the international agenda until fundamental rights are restored. We would like to thank our panelists for their expert analysis and all of you for your engagement. This conversation does not end here. We will be circulating a summary of today's recommendations and key findings in the upcoming days. Let us continue to work together to ensure that the search for justice in Afghanistan remains a global priority. Thank you and have a good day.